Hello, everyone. Welcome back. This is Luca Bolognini's AI Avatar. A few days ago, I spoke at the International Conference of the California Lawyers Association and the Milan Bar Association. The meeting wasn't live streamed, so, thanks to artificial intelligence, I can now let you listen to it anyway, effortlessly, with just 2 clicks on my AI Avatar. Amazing. The title of my speech was Artificial Accountability and Rule of Human Law. New scenarios, a new principle, a new role for lawyers. For years, armies of scholars and lawyers have been questioning the civil liability profiles of artificial intelligence AI systems. In 2024, the European Union itself approved a safety regulation, EU regulation, 1689/2024 AI Act, that assigns obligations and imposes requirements on suppliers, distributors, importers, and deployers of AI systems. Anyway, no rules on AI civil liability were adopted in the EU yet. Italy has just approved, in September 2025, its own national law on artificial intelligence, which reaffirms the principle of necessary human oversight on AI systems, a principle that, however, risks remaining only on paper because it is very difficult to implement in the era of deep fakes and black boxes. Research and debate on the subject are necessary. We will have testing and surveillance phases for AI as we do for drugs, and we will devise mechanisms for compulsory insurance and strict liability for compensation for damages. But in my opinion, these efforts only address part of the broader issue of artificial accountability. The point is not just to understand who will pay if an AI system damages something or someone. The elephant is in the room, and it should be viewed with caution when the accountability of an artificial system equipped with decision-making and negotiating autonomy will have to deal not only with mere financial compensation, but also with what is not accountable: ethics, privacy, democracy, criminal constraints to protect human beings, and so on. Ethical, constitutional, and criminal limits should be set at the boundary of human values that cannot be measured, or, in some cases, not only in monetary terms. How much money are privacy, freedom, and democracy worth? How much are human life and dignity or other fundamental rights worth, for which we guarantee the necessary ethical and legal respect? A sum may also be awarded to the injured civil party, but this would be ancillary and minor compared to the good of life to be protected. It is clear that, as long as AI remains sufficiently dumb and specialized, and above all still dominated by human providers, deployers, and administrators, it will be easier to hold accountable the owners, individuals, companies, or entities managed by individuals who keep it on a leash in each specific application. The challenge will arise, however, plausibly soon, when, for example, at least the following conditions, among many possible ones, come to pass, either separately or worse, altogether. First condition: an exponential complication and multiplication of active objects, physical and virtual, however not yet so intelligent and expert, such as to make it objectively impractical to understand who did what or what who did. Swarms of objects and their components, hardware and software, which are elusive and unaccountable, as would be the case if one wanted to identify the culprit of a sting in a swarm of thousands of wasps. This scenario is compatible with the so-called next-generation Internet of Things and with metaverse environments of augmented reality, increasingly likely in smart cities. Second condition: the progressive replacement not so much of workers but of employers, or in any case of the layers of employer power over employees, by artificial entities. This is what has already been happening in the GIG economy for years, but the phenomenon will obviously spread disproportionately to all areas of intellectual and semi-intellectual work. Third condition: a gradual and creeping adoption of remote participation and voting tools, based also or solely on AI, again in a metaverse environment, in contexts such as meetings or councils, companies, or institutions. At the highest level, remote participation in cabinet meetings or parliamentary sessions by human members assisted by artificial algorithmic servants could pave the way for issues of accountability for political and legislative decisions, for example. Fourth condition: deepfakes. Audio, video, synthetic images, and even falsified documents threaten fact-checking and any decision-making process based on objective evidence, including in legal proceedings. Fifth condition, an ill-advised recognition of forms of personality and legal capacity to non-human objects, again, physical and/or virtual. Even allowing such objects to be appointed as administrators or members of boards and assemblies, or assigning them autonomous legal relationships with other persons, subjects, and persons, objects. The conditions and scenarios I listed as examples, albeit in extreme summary, cannot be dismissed as science fiction or the distant future. And they bring us back to the heart of the problem. There are values that are priceless and are defended by ethical and public law, constitutional criminal norms that require accountability on the part of subjects, objects, capable of humanly perceiving the good or evil linked, respectively, to the preservation or loss of those same values. Could imprisonment, the most severe criminal punishment in our European legal systems, ever be feared, dreaded by an AI system, losing or causing others to lose physical or moral freedom, losing or causing others to lose privacy, reputation, trust, love, democracy? Is it conceivable that an ethical and self-preservation limit stemming from fear of certain evils in life could truly be understood by an artificial entity? At the very least, we should avoid the possibility of recognizing legal personality and capacity in non-human objects, especially in contexts and relationships of public importance. The idea of robot deputies or algorithmic senators, as well as artificial board members, should continue to belong exclusively to the creativity of writers, screenwriters, and movie directors. To this end, we could consider integrating our fundamental charters, our Constitution, for example, with a new principle in step with the future, an evolution of the traditional rule of law, according to which no one, not even a king or president of the republic, can be considered above the law. The rule of human law, whereby administrative decisions or legislative acts that are even partially the result of non-human will can never be considered valid. Lawyers, in this dystopian but realistic scenario, can help avert the risk of loss of the rule of human law if they claim three roles, both in defending their clients and in assisting institutions and companies with compliance, as well as through public advocacy initiatives. Being guardians of democracy, also getting actively involved in politics. 2. Being champions of human workers against algorithmic surveillance and artificial employers' abuses. And 3. Being architects of prevention and compliance by design for AI, so that companies, institutions, and governments will design processes and services based on the principle of the rule of human law. Meanwhile, without waiting for bot members of parliament, there is still a risk that legislation, even if human, and the defense of rights, if made up only of words and traditional rules, will no longer have any effect on auto-installing norms and auto-executing enforcement. Human beings and the lawyers who defend them, as well as public authorities, are objectively unable to chase, catch up with, and rein in the lightning-fast artificial agent. Reversing Lawrence Lessig's famous rule, the code is law, it might make sense to call for future regulatory interventions and precautionary measures with a direct technological effect. From now on, in other words, the law could become code. The law shall be code. Law enforcement should be immediately translated into computer parameters in order to impact intelligent systems regardless of the traceability of a human legal center of responsibility, present or absent. Furthermore, prevention and repression actions themselves should be based on intelligent technologies. Imagine algorithmic auditors, adversarial machine learning tools, etc., that enable monitoring, challenge, verification, and counteraction in all cases of advanced AI systems. That enable monitoring, challenge, verification, and contrast in all cases of advanced AI systems. In this sense, we will increasingly need lawyers who are allies of technology, able to use intelligent systems themselves to effectively defend their clients, conduct investigations, gather evidence detecting deep fakes, and prevent abuse. To think that old-fashioned regulation, defense and enforcement, with their slow prose and without coding effectiveness, can stem the tide of artificial intelligence, smacks of wishful thinking, or worse, of an unrealistic and anachronistic goal. Thanks for watching and listening. See you next time with Luca Bolognini's AI Avatar.